Jim Carlton with the Wall Street Journal. Congratulations. A question for Mr. Boies and Mr. Olson. What gives you the confidence that you can win in the Supreme Court given the fairly conservative makeup of that body? Thank you.
Well, Ted and I have a deal. He's going to get the 5 justices that voted for him in Bush v. Gore, and I'm going to get the 4 justices that voted for me in Bush v. Gore. In addition to that, one of the things that the Judge Walker makes clear in his opinion is this does not ask the courts to establish a new right. The fundamental right to marry is already established by ample Supreme Court precedent. And this case does not ask the courts to establish a new right for gay and lesbians not to be discriminated against. That right has already been established in United States Supreme Court precedents over the last 10 years. All this case asks is that the court look at 3 facts. Is marriage a fundamental right? The court has already held it. Does depriving gay and lesbian citizens of the right to marry harm them and harm their children? There is no dispute on the record that that is true. And does depriving gay and lesbian citizens of the right to marry advance any legitimate state interest? The defendants could come forward with none. We know of none. The evidence is to the contrary. In light of that, we believe the constitutional violation of depriving gay and lesbian citizens of this fundamental right is very clear. And we believe that that will be held by the Ninth Circuit Court of Appeals and by the United States Supreme Court.
We're getting reports that Bevan Dufty is trying to marry a couple right now at City Hall. And as I understand, the judge has put a stay on this decision for 2 days. So what is the likelihood that marriages can occur right now at City Hall or tomorrow or the next day? And would you 4 go get married in that time frame?
Well, what the judge apparently did, as I understand it, is stayed the effect of his decision until he could hear an opposition from us to the application for a stay. We don't know what the judge will decide, and we don't pretend to predict what the judge will decide about that. The case is going to go up to the Court of Appeals. I will say this, we are going to fight hard so that the constitutional rights vindicated by the 138-page, very careful, thoughtful, analytical opinion from this judge will be brought into fruition as soon as possible for the citizens of California. We will also say, to the extent that a Court of Appeals wishes to stay the effect of the decision until there can be an appellate court determination of the validity of this opinion, we will say that this judge has found, after the most exhaustive trial that you could imagine, that the constitutional rights of these individuals are being violated every day. To take away your constitutional rights to equality is an irreparable, irremediable, destructive injury that happens to you every minute of every hour of every day. And the longer that goes on, the more damage that's done to more members of the citizenry of California, all citizens of California, not just gay and lesbian people, but all citizens of California who value the principles that undergird our Constitution. So we will say to the Ninth Circuit Court of Appeals, if there will be any delay at all, it should be exceedingly short. We've briefed the issues. There could not be a more thorough analysis of the facts. We're ready to go. We need to have an appellate court decision right away, and we need ultimately a Supreme Court decision right away. So I don't want, and David I'm sure doesn't want to predict when anything is going to happen next, but we're going to fight to vindicate these rights, constitutional rights, as quickly as we possibly can, and we now have the confidence that all of the facts that could be presented by the proponents of Proposition 8, that all the facts that they could bring forth gave the judge no single reason to continue this discrimination. The judge found that the Constitution requires equality now, and there's no basis, no rational basis, or any good reason to prevent this continuing damage from going on. So we're going to fight hard to get this done as quickly as possible. From the moment we started this case, which was just over 14 months ago in May of 2009, we've moved as fast as we possibly can. We've moved the justice system as fast as we possibly can. We're not going to let up now.
It's more of a personal answer, but I would want to be surrounded by my family and my friends. I'd want us to be able to celebrate that with our immediate families, and I need time to order cake.
Did the judge rule on the issue of suspect class, and could you discuss your thinking on his rationale on that issue?
The judge ruled that this was a suspect class. The judge ruled that strict scrutiny was therefore required, but the judge also ruled that even if it was not a suspect class and strict scrutiny was not required, there was no rational basis for the discrimination, no rational basis for depriving gay and lesbian couples of the right to marry. So, yes, the judge held it was a suspect class, but he held even under the most deferential standard of review, this legislation, this initiative was unconstitutional.